Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers trespassing, the state action doctrine, and mistaken identities, and is brought to us by Tony Effin Wynn's channel. Be sure to check out the description below and give them the credit that they deserve. On November 27th, 2022, Tony Wynn and his girlfriend Lauren Caldwell were shopping at a Wal-Mart location in Spring Hill, Florida, as they had many times before, when Wal-Mart asset protection specialist David Pettigrew mistook Mr. Wynn for another individual named Cody Vondelinde. Because Mr. Vondelinde had been trespassed from that Walmart location in 2018 and was not permitted to return, Mr. Pettigrew called 911 to report that Mr. Vondelinde was in the store. However, Mr. Pettigrew admitted on the call that he did not get a good look at the individual he believed to be Mr. Vondelinde because he did not want to make eye contact with him. Deputy Michael McNeely of the Hernando County Sheriff's Office responded to the call, and Mr. Pettigrew pointed him toward Mr. Wynn, asserting that he was Mr. Vondelinde. According to Deputy McNeely, he called out, "Cody," as he approached Mr. Wynn, and Mr. Wynn turned around. Deputy McNeely immediately placed Mr. Wynn in handcuffs, and Ms. Caldwell began to record the encounter on her cell phone.
Does not matter. A year?
Yes, you can't come back.
That was like 10, 15 years ago.
No
What are you talking about?
There's no limit on that. When
We
you
are
trespass,
grocery
you can't come
shopping.
back.
What are you talking about?
You're trespassing, so you're not allowed to be here, alright?
Where are you taking
Well,
him?
once you trespass as well, so let's go.
For what? For grocery shopping?
That guy right
No,
there.
for being trespassed.
For grocery
Hey,
shopping?
look, record him right there. Look, record him too. That fat guy.
What is going on?
He a cop too.
Where are you taking
Why are
him?
you pulling me? You don't have to pull me. You know I'm disabled, right? I have back issues. You don't have to pull me, sir.
You should be ashamed of yourself. I cannot believe you're doing this. Where are you taking him? Where are the keys?
In my pocket.
I cannot believe you're doing this. You should be ashamed of yourself. I need the keys.
Step away.
Hold on, calm down. Just calm down. Just calm down.
I'll give her the car keys.
This is disgusting.
Sorry you feel that.
Sorry, I feel that way. No, that's a fact. You should be ashamed of yourself. What did he do? He has not done anything.
That's not true.
This is like 10 years ago.
I get you. But when you're trespassed, you can't come back.
No, they told me in court it was only a year.
We'll get all that sorted out, alright? If that's true, I'll let you go, okay?
Mr. Wynn tells Deputy McNeely that although he was trespassed from the store about 10 years ago, the court informed him that the warning only lasted for 1 year, and Deputy McNeely replies that he will investigate this claim. It seems that Mr. Wynn is referring to a 2013 shoplifting arrest that resulted in him being trespassed from the Walmart in question. Although the court records from the criminal case do not include details about the length of the enforceability of Mr. Wynn's trespass warning, it is more than feasible that a trespass warning could expire, and an individual could be re-invited to shop at the store. Under Section 810.08 of the Florida statutes, quote, "Whoever, without being authorized, licensed, or invited, willfully enters or remains in any structure, or having been authorized, licensed, or invited, is warned by the owner or lessee of the premises, or by a person authorized by the owner or lessee to depart and refuses to do so, commits the offense of trespass." In general, when privately owned property such as a Walmart store is held open to the public, the owner of the property is considered to have issued an implied invitation to members of the public to enter without express permission. However, by issuing a trespass warning, the owner or their agent can revoke a certain individual's invitation to enter the premises, so that if they return to the property, they do so without being authorized, licensed, or invited to enter and violate the trespassing statute. In this situation, Walmart may have issued a trespass warning to Mr. Wynn in 2013 that was only valid for a year. Once the trespass warning expired, Mr. Wynn's implied invitation to shop at the store would be considered to be reinstated, and he would be able to enter the Walmart without trespassing. However, even if the trespass warning did not have an expiration date, Mr. Wynn would have an argument that he did not violate the trespass statute because he had regularly been shopping at the Walmart location in question without any issues. Based on this fact, Mr. Wynn may be able to assert that his invitation to shop had been reinstated by the store's acquiescence to his repeated presence, though legal precedent supporting this argument is limited.
Are you good to take his items for me? Hold on to them. Thank you. And these are all his items, correct? Yeah. Okay, very good. All right, can you follow more?
You guys should be ashamed of yourself. You should be ashamed of yourself. We are literally trying to grocery shop and Christmas shop. It's disgusting. Shameful.
Yep. Ma'am, what's your name? Step in here real quick. Please don't film in here. This is off limits, okay? It's a private establishment. They don't want you to film. Okay? They don't want you to film in here. It's a private establishment.
Well, then I'm not stepping
That's fine.
inside.
What's your name?
Deputy McNeely states that the Wal-Mart employee, who is presumably Mr. Pettigrew, does not want Ms. Caldwell to film inside the office, so she refuses to step inside. As we have discussed many times on ATA, several federal circuit courts have recognized that the First Amendment protects the right to film in public, including the 11th Circuit, which has jurisdiction over Florida. In the 2000 case of Smith versus City of Cumming, the 11th Circuit Court of Appeals held that individuals have, quote, a First Amendment right, subject to reasonable time, manner, and place restrictions, to photograph or videotape police conduct, and that, quote, the First Amendment protects the right to gather information about what public officials do on public property, and specifically, a right to record matters of public interest. However, it is important to note that the First Amendment by its terms only prohibits government actors from abridging the freedom of speech, and does not apply to the actions of private persons. As the Supreme Court explained in the 2019 case of Manhattan Community Access Corp. Versus Halleck, quote, the free speech clause of the First Amendment constrains governmental actors and protects private actors. To draw the line between governmental and private, this court applies what is known as the state action doctrine. The court also noted that under the state action doctrine, quote, a private entity can qualify as a state actor in a few limited circumstances, including, for example, when the private entity performs a traditional exclusive public function, when the government compels the private entity to take a particular action, or when the government acts jointly with the private entity. Now, while Wal-Mart is open to the public, it is highly unlikely that a court would conclude the store performs a, quote, traditional exclusive public function, because, as outlined in the Halleck case, a private entity only qualifies as a state actor under this exception when it exercises, quote, powers traditionally exclusively reserved to the state, and, quote, it is not enough that the function serves the public good or the public interest in some way. For this reason, Wal-Mart almost certainly has the right to ban filming on its property. And, in fact, according to the Wal-Mart website, the company has instituted a policy prohibiting, quote-unquote, unauthorized filming inside stores. Now, Ms. Caldwell's situation is more complex than Wal-Mart simply restricting filming in its stores, as Deputy McNeely was the one who informed Ms. Caldwell that she was not permitted to film. And although there may be an argument that this was state action that infringed on her right to record, given the fact that Deputy McNeely simply appeared to be expressing the wishes of a private party to limit filming in a room that was not open to the public on private property, a court would probably conclude that Ms. Caldwell's First Amendment rights were not violated.
The manager here is requesting that you be trespassed from here. If you come back, you're subject to arrest. Do you understand that?
Walmart?
From this Walmart. He's asking
But
that
I
you be
don't
trespassed.
understand why.
He doesn't have to have a reason. If you have a house and you don't want someone at your house, for whatever reason in Florida, you can have them trespass. It's the same for Walmart. He's asking that you be trespassed. I'm giving
I've
you a
done
warning.
nothing. I understand,
It
but
doesn't.
I would like a reason.
You don't have to have a reason in Florida.
Really? I think
Dead
that's
straight.
crazy.
It is. This is your
I
warning.
understand.
Okay.
I'm just discussing it.
So the reason why he's going to jail tonight is because he's been warned in the past. There's no time limit on it.
You're taking
I'm
him
going
to jail?
Yes, it's called trespass after warning. He gave him a warning in the past,
When?
and he's back. I'm going to go double check that so I don't have an exact date. Right now, he's being detained. He's not under arrest because I have a crime at hand. I'm going to see if the crime, if I have probable cause for the crime. It's a misdemeanor. It's not a big crime.
But you're
It is a
taking
crime.
him to jail?
I'm going to verify that before I do. He's being detained right now, okay? So I need you to leave. You're being trespassed, okay?
Deputy McNeely informs Ms. Caldwell that she is being trespassed from the Wal-Mart location and that the store does not need to have a reason to do so. In general, this statement is mostly true, although there are legal limitations on a business owner's ability to discriminate based on protected classes, such as race, religion, or national origin. As the Supreme Court of Florida explained in the 1976 case of Korn versus State, where property such as a shopping mall is, quote, privately owned but utilized for monetary gain and hence open to the public, it is considered quote-unquote quasi-public in the nature of its use because, quote, an invitation is extended to the public to shop to the financial advantage of the owner. For this reason, the court noted that, quote, reasonable non-discriminatory restrictions pertaining to the use of the mall may be placed on the users, such as the requirement that shoes be worn. As any invitation, it can be limited, and upon abuse, be withdrawn or revoked. In other words, as the 5th District Court of Appeal of Florida summarized in the 1993 case of State versus Woods, although, quote, shopping malls are quasi-public places which must be open to the public on a non-discriminatory basis, the owner of such a mall does not lose all control over its private ownership interest. Given Wal-Mart's similarity to a shopping mall, it seems likely that a court would recognize that Wal-Mart has the right to terminate an individual's invitation to shop there based on reasonable, non-discriminatory grounds, while also limiting the store's ability to ban shoppers for no reason whatsoever.
I'm not leaving him. I'm not leaving him. And I always support you guys, but this is disgusting. This is horrible.
So the trespass has been confirmed. He has been trespassed here actually this year. So he will not be staying here. He's going to be going to jail tonight. He will have a bond. You'll be able to bond him out, okay? Does that understand? You understand that?
After confirming that a trespass warning had been issued for Mr. Vondelinde, Deputy McNeely informs Ms. Caldwell that Mr. Wynn, whom he still believes to be Mr. Vondelinde, is being arrested for trespass and taken to jail. In the 1971 case of Hill versus California, the Supreme Court upheld the constitutionality of an arrest of an individual when the officers mistook him for another individual, concluding that, quote, when the police have probable cause to arrest one party, and when they reasonably mistake a second party for the first party, then the arrest of the second party is a valid arrest. The court noted that although the officer's so-called subjective good faith belief that they had arrested the right suspect would not in itself justify the arrest, quote, when judged in accordance with the factual and practical considerations of everyday life on which reasonable and prudent men act, the arrest and subsequent search were reasonable and valid under the Fourth Amendment. While it seems that Deputy McNeely did have a good faith belief that Mr. Wynn was actually Mr. Vondelinde, whether or not a court would conclude that this belief was reasonable is less clear. In reaching the mistaken determination that Mr. Wynn was Mr. Vondelinde, Deputy McNeely relied on Mr. Pettigrew's identification, along with the fact that Mr. Wynn apparently turned around when he called out the name Cody, and courts have consistently held that officers may rely on information from witnesses with personal knowledge of an event when making an arrest. However, Deputy McNeely failed to take any other steps to confirm Mr. Wynn's identity, and it is possible that a court would conclude that his lack of reliable information about Mr. Wynn's identity could render the mistake unreasonable, thereby making the arrest unconstitutional. That being said, courts have long recognized that officers are not required to explore every avenue of investigation or even sift through conflicting evidence before making an arrest, and it is also possible that a court would determine that Deputy McNeely's mistake was reasonable.
This is horrible. We just came from the Springs. We were in this Jeep with a boat and a trailer.
I got you. But regardless, I need you to get in the car and drive away because if you come back here, you're going to also be going to jail for trespass, okay?
This is disgusting.
I'm sorry you feel that way.
Can I speak to him?
It's up to him. Make it quick.
Can we call Mike?
Can I at least get my phone and take my medication first, sir? Because
You can't take any medications before going to the detention center. Whatever you need, they can get you there.
Can I have my phone? And call Mike. That's fine.
You can take your phone if you want. You can't use it.
No,
you can take it.
Yeah, I just need it for phone numbers, yeah.
Yeah.
Do you want her to drive it away? Because she's also trespassed from here. She can't hang out here.
I'm going. I can drive it.
You sure?
I'm just going to go to Mike's house, yeah. I'm going to call them.
Just drive into the next parking lot or something and then pull over and then have Mike come get it. That's fine. Is that all right?
That's fine.
Yeah,
that's fine.
As long as she leaves Walmart property.
All right.
After the arrest, Deputy McNeely drove Mr. Wynn to the Hernando County Jail, where he collected Mr. Wynn's identification for intake and discovered that he was not Mr. Von der Linde. After confirming Mr. Wynn's identity, Deputy McNeely apologized to Mr. Wynn and began to drive him home. However, while still en route, Deputy McNeely received a phone call from his supervising sergeant, who requested a picture of Mr. Wynn and his identification. Deputy McNeely then detained Mr. Wynn on the side of the road while his supervisor conducted an investigation. And when Mr. Wynn's previous trespass warning was discovered, Deputy McNeely drove Mr. Wynn back to the jail to book him for trespassing. On November 29, 2022, Mr. Wynn was officially charged with trespassing. But on January 25, 2023, the Assistant State Attorney filed an announcement of no information that stated that the case did not warrant prosecution, and the case was dismissed that same day. In January of 2023, the Hernando County Sheriff's Office issued a statement attempting to justify the officer's actions, arguing that, quote, the trespass warning issued at Wal-Mart was still in effect after having never been rescinded by officials there. Therefore, probable cause existed for the arrest of Tony Wynn for the trespass in question. He was processed and charged accordingly. On March 2nd, 2023, Mr. Wynn filed a federal lawsuit against Wal-Mart, Mr. Pettigrew, and Deputy McNeely, alleging $10 million in damages for claims including racial profiling, false imprisonment, and false arrest. As of the date of writing this episode, this case is still pending. Overall, Deputy McNeely gets a B- because although he arrested the wrong person, it seemed to be a genuine mistake, and he immediately apologized to Mr. Wynn when he discovered his error. Deputy McNeely also maintained a professional demeanor throughout the encounter and demonstrated a reasonable understanding of Florida's trespassing laws. That being said, his failure to take any actions to confirm Mr. Wynn's identity before arresting him was a substantial oversight, particularly in consideration of how simple it would be to ask Mr. Wynn for his name or identification. This interaction demonstrates how even well-meaning officers can make mistakes that violate the Constitution. And although I cannot say for certain whether a court would conclude that Deputy McNeely's actions infringed on Mr. Wynn's rights, his error certainly had a profound negative impact on Mr. Wynn. Mr. Wynn and Ms. Caldwell get an A+ for calmly and respectfully voicing their confusion and dissent while still complying with lawful orders, recording the encounter on Ms. Caldwell's cell phone, and taking appropriate legal action to challenge the constitutionality of Mr. Wynn's arrest. Although the legal issues involved in this case are far from black and white, I commend Mr. Wynn and Ms. Caldwell for taking a stand against the injuries that Mr. Wynn experienced. Regardless of the outcome of the legal case, their actions have raised awareness among the community regarding these important subjects, and have hopefully served to remind police officers who hear about this situation of the importance of conducting thorough investigations. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.